Welcome, and thank you for joining our FirstService Residential webinar. My name is Asa Sherwood, and I'm the president of FirstService Residential, Illinois. Before we get started with our panel today, I wanted to take a moment to thank our clients who have remained open-minded while partnering with us to best guide their residents through these times of uncertainty. As you know, there's no playbook or one-size-fits-all approach to managing through a pandemic like this, and I've been extremely pleased with the continued support and trust we feel from our clients every day. I also want to thank all of our FirstService Residential Illinois associates. It has been over 2 months since we made the difficult decision to move 95% of our associate base to a work-from-home model. We're all balancing concerns for our clients, residents, families, friends, and our own health. Through all of that, our associates continue to deliver the level of service our colleagues and clients have come to trust from us and our organization. I'm proud and inspired by the way our associates continue to handle this challenge. Thank you for your tremendous focus and care for each other and our clients. Today, we've put together a panel of industry experts to discuss the ever-changing environment we find ourselves in and explain how our clients can prepare for the months ahead. As a result of our collective mitigation efforts, indications are that stay-home orders will gradually ease as pandemic conditions improve across Illinois. As such, we have been preparing for and planning to guide our clients through the reopening phase which lies ahead. Our panel today will discuss some topics and strategies we are implementing to assist our clients. Participating in our panel today and discussing community operation tips, we have Jessica Tolles, Vice President of FirstService Residential, Laura Marinelli from the law firm of Saul, Ewing, Arnstein and Lair, and Ian Novak, Vice President of FirstService Residential. Additionally, Sean Kent, Senior Vice President of Insurance at FirstService Financial, will be discussing the pandemic and how it's affecting the insurance market and our communities. Now, I'll hand it over to our first speaker, Jessica Tolles.
Thank you for that, Asa. We're going to start today by talking about reopening your association. As our state begins to lift restrictions on social distancing and our stay-at-home orders, we want to talk to our boards and our managers about how to effectively and safely reopen clubhouses, building spaces, and amenities. So today we have Laura Marinelli is going to join me as a subject expert along with Ian Novak and Sean Kent. They're going to come in, as Asa introduced, and pepper in any additional knowledge and key points that they have. But Laura and I are probably the majority of this first section here. We want to start at the basics. Really, every association with any decision that they're making needs to keep in mind various state statutes, federal laws, local municipal ordinances, various things that are going to lay the groundwork and the basis for decisions that the board is making on behalf of the community. This time is no different, but the change is that all of these various recommendations and orders and guidelines and even laws that are being passed are changing so frequently, it's hard for any of us to be able to stay on top of what's going on. We need to be mindful of the various topics and documents and information that the board needs to take into consideration before making decisions for the association as they approach reopening communities and amenities. There are a number of federal orders and guidelines coming out from the CDC and a number of different areas, but we also have homeowners who are reading those documents and talking about them on social media and begging the board to open the pool and do various things. You need to take into consideration what those documents are from the real source and not interpretations of those documents from social media or other websites. Our state has a 5-phase reopening plan that associations as not-for-profit businesses do need to take into consideration. Some of those specific guidelines as we go into reopening are the limitation on the number of people and the social distancing. So we're going to talk about the number of people that you can have in a particular area and the social distancing and how to facilitate that and what kinds of logistics go into making that happen and how those logistics and those specifications will impact your decision making as a board. For those of you who've closed down your pools and your clubhouses and everything is winterized and not being used currently, if your clubhouse is normally being used and your water is typically flowing on a regular basis, it's now been stagnant for a while. Your manager, your board, you need to be looking to your contractors and your other business professionals to look at things like the Illinois Department of Public Health put out a notice and a memo last week about how to reopen your clubhouses if your pool system or your drinking water or your HVAC system has been stagnant and not operating because you shut down the building. What kind of disinfecting needs to be done in order to minimize other diseases and things that can happen when you have a water system that sits? You can leach minerals and things out of the pipes that has to be cleaned out. There's always a risk of Legionella that forms. So what kind of things need to happen? So if you're reopening an area within your community that has been shut down and not in use, you need to talk to your professionals about what steps need to be taken to safely and effectively reopen those areas. And what is always at our forefront in community association management is we need to take into account the needs of our staff and our owners. Our homeowners are important, and every single community is different. Your demographic and what could work for your association or your community will be different than any other association. Every single community is unique in its demographic, its building style, construction, the various issues that you have every day. So as a board, you need to take into consideration the specific needs of your association. There is no one-size-fits-all cookie-cutter plan to reopening the association. So these are some of the things that we're going to talk about over the next couple of minutes. Starting off, as we're creating our plan, we as an organization have put out our reopening guide for our community associations. Now, this is a very broad brush document. It takes into account any and every type of amenity that you could possibly face as an association, from tennis courts, bocce balls, pools, fitness centers. So really, this is the big picture that you can whittle down and utilize those pieces as needed for your association. If your manager has not already shared this document and template with you, certainly feel free to reach out to them or the regional director for your community so that we can get that moving and use that tool to help shape your reopening plan. But as we have Laura and Sean here, Laura, utilizing your professional team in speaking about those various documents, what are some of the pitfalls that can happen as boards are attempting to make these decisions and looking at these various documents?
There's a few things that I'm seeing that can happen that can be a little bit dangerous for our boards. Is that one, there is no clear answer to every one of these questions. Many of these areas are still somewhat gray, and as you mentioned, there are so many orders coming out from various organizations, governmental positions, the local government, the state government, the federal government, that we have to be sure that we are not misinterpreting those based on things we're seeing online or in social media interpretations. You need to be relying on your professionals. Legal counsel is there to help you interpret those documents and help you understand which of those regulations apply to your particular building and your staff and the amenities you have to make sure that you're operating under the right interpretation of those things. That's the first thing that I think is really critical. The other thing is that there are some areas that are somewhat gray, and based upon the configuration, as you mentioned, Jessica, or the makeup of your building or the physical attributes of the building, that boards are going to have to make informed decisions about these things. So they need to be understanding the facts of their building, the setup that they have, taking those things into consideration, and then relying on their professionals so that they are making informed decisions rather than just going based on what they're hearing people say or sort of an emotional response to this very difficult situation that we're all finding ourselves in.
Mm-hmm. That is a great point. The emotional response is really kicking up now, and we're seeing an uptick in social media posts from our clients and the homeowners asking, why am I paying a full assessment? When can I get something back? Why are we going to pay for the pool? So it's important for our boards to be communicating in advance. We're going to talk about that in a moment. But as the board is taking all of these pieces of information under consideration, how are these decisions being made? What's the best practice for our boards to implement changes in policy or these decisions that they are making?
Well, first, there should be conversations that occur before these decisions actually get implemented. So it's really important. Boards have to remember that while you have to conduct your business in an open meeting, and all voting in essential decisions have to be made in open meetings, you do have the ability to discuss certain topics with your legal counsel outside of those open meetings. You should be having those conversations or with contractors and making sure that you have all the information before you're making these decisions. Then if you're going to make a decision or change a procedure or implement a new rule, remember, we still have to follow the policies and guidelines and statutory requirements for passing those things. We can't just go in one day and say the next day we're going to change this rule without going through the procedure. Your managers and your lawyers know these procedures. Make sure you're talking to them and you're allowing yourself time to take proper steps to do it lawfully so you don't have open challenges to these issues later.
Excellent. That's a great point, that boards still have the opportunity to have conversations and discussions under the executive order provisions in both the Condo Act and the Common Interest Community Association Act. So they should be conferring with their attorney and their trusted professional advisors before they have decisions in an open meeting, so they're not making knee-jerk reactions or knee-jerk decisions based on feedback that they're getting from homeowners. As we're managing our owners' expectations, communication really is of the utmost importance. And this would be our next slide. One of the biggest problems we're facing now is the rumor mill that happens within associations right now, and justifiably so. Whether or not you make a decision to open your pool or not, that is a hard decision to make. But in a lack of information, homeowners are making up their own story. They're making assumptions. They're coming up with their own narrative. If you are still waiting, tell your homeowners why. Talk to your homeowners. This is why we're not opening up our amenities. We've kept our fitness center closed because we're waiting for further guidelines from the Illinois Department of Public Health or from the governor's office. We are waiting to make thoughtful decisions about your safety prior to opening these up. Tell them what's going on, even if there's not a lot of meat behind it. At least you're letting them know what's happening and why a decision hasn't been made yet. We have to pivot with that as well. As we said a few minutes ago, these restrictions and guidelines change by the minute. So your board of directors has to be prepared to continually reevaluate the plan, what you're doing, and then communicate on that plan. Take immediate action to let your homeowners know what's going on. Likewise, we have to take into consideration the budgetary impacts that these may or may not happen. Many of your homeowners are probably asking, why hasn't my assessment gone down yet? Are you still going to collect the entire amount for this year? We need to start talking about that narrative as well. And I know the 2021 budget is still 7 or 8 months away, but you have to start talking about and thinking about that now and preparing your homeowners for what reasonably can or cannot happen with your assessments. We see communication all over that homeowners are expecting no increase next year or for their assessments to be reduced, but you need to work again with your attorneys, your insurance, your engineers, your property manager, everyone in your toolbox to determine what is reasonable, because it may not be reasonable for your association just to cut assessments in half and allow homeowners some leeway in their financials, because unfortunately you still have to run a business and you still have to maintain the physical elements. That's part of your fiduciary responsibility. So thinking about those things now, managing those expectations, having those discussions 6 months out so that we're not waiting until the very last minute to make those decisions and then having to communicate. And again, be prepared to modify and move and change and be fluid over these next few months. Change is hard for people, and we're stuck in the middle of a very tenuous time. It's hard for us to be so apart from other people. So our nerves are on edge. We have to have some grace with our homeowners and be willing to over-communicate and continue to communicate with them to keep things flowing appropriately. Are there any other ideas that you have on feedback or communication or what boards can be doing, Laura, as far as keeping their owners in the loop?
I mean, I think, Jessica, I think you hit it on the head. The key is really communication often, early, and as fluid as a manner as you can. There's a reason that we're seeing the governmental departments have daily press briefings, and we're seeing updates issued every day, because right now we're in such a time of uncertainty. No one has the ability to know what's going to happen in a month or 2 weeks or even a week from now. So if there is communication flowing, I think it has at least helped lessen the anxiety that a lot of people are feeling about this, and it's helped with managing expectations, like you said, which is really critical. So as long as you're having those open communications and you're continuing to keep people, apprised of the fact that even though you might not be able to make a concrete decision about something today, that you're considering it, you're developing a plan, and when you do have the information available to you to make those decisions, that you'll be informed and prepared to do that to the best of your ability, I think it will help at least lessen some of the sort of concern that we're seeing from the residents in the buildings at this point in time.
Yeah, and I think that ties directly into risk management as well, Jessica and Laura. I mean, you mentioned it earlier, there's just so many gray areas here and so much uncertainty, and that's certainly true within the insurance, the insurance business right now, where we just don't know what's going to happen with these types of claims, how they're going to evolve from a liability standpoint. Case law is going to have a lot to do with it, and the best thing that boards can do is to have a backstop that really began with communication and over communication. So whether or not they're going to open the pool or not, why are they making these decisions? Even things as simple as signage, in any common areas in terms of, guest policies, visitor policies, cleaning, you name it. I think all of those things go a long way to protecting boards and associations in the long run.
And if I can add, Jessica, I mean, the back to basics communication, I mean, all of us are saying the same thing about communication. You should build a cadence of communication to your community as a management team and as a board of directors. Even if it's repeating the same message because there is no new message to deliver, repeating is very important, especially in this day and age. If a community has not built a cadence with its community as far as repetitive communication to its community, now is a great time to start, because that will stop the rumorville from happening.
As human beings, we need to hear things multiple times. There's a cadence we talk about within our organization, 10 times, 3 different ways. People need to hear things repetitively over and over and in multiple channels. If you send an email to your homeowners, post a notice as well. Have things in multiple media formats. That's going to help people remember the message and get that really through to your homeowners. We do have a couple of top questions and concerns relative to reopening, some hot spots that our communities and boards have been talking about. So I want to talk about some of these issues. I'm going to go out of order because really it is the hot topic right now, because Memorial Day weekend is almost upon us or already passed, and we need to be cognizant of our pools. So, Laura, we have had so many people asking us about pools. What do we do? How do we do it? We know there's social distancing, 6 feet apart. We know right now, at least in phase 2, we have to limit the number of people to 10 in any area outside of our home. How do boards make a decision about whether or not to open their pool or not?
So you're right. This is the hot topic, and it's getting to be that time of year, and everyone's ready to get out there, and I can completely understand that. Unfortunately, as you mentioned earlier, we have this five-phase program here in Illinois. We're currently in phase 2, awaiting anxiously everyone to see if we get upgraded or promoted to phase 3 in the near future. But as you mentioned, even with phase 3, there are restrictions in place, meaning that we can still only have groups of up to 10 people with social distancing requirements outside of our immediate residents or family members. And so that presents a number of practical and logistical issues for associations to consider when trying to determine whether or not they can open their pool. And this is important, again, to remind everyone that every building is going to have different considerations. Your makeup of your pool, the number of people that live in your building, the size of your pool area. There are going to be a number of things that are going to come into play in determining whether you think you can safely open the pool and you can do it in compliance with these requirements. Until we get to phase 3, we really can't even consider opening the pool. But at phase 3, we have to talk about things such as the layout of the pool, where the equipment is, how do we make sure people are still 6 feet apart, how do we ensure we have less than 10 people at a time, do the buildings come up with some type of a schedule or a sign up for allowing people to use the pools at certain times and limiting it to those 10 people. But then you run into, of course, the sort of glaring elephant in the room, which is how do we enforce that? And how do you make sure that everyone gets an opportunity to use the pool and have equal time? And then that leads us into the whole next list of questions. How do we sanitize in between those visits? What's safe enough? How much time do we need to allocate for that? Who is going to be doing it? Do we have staff available? Do we need to hire an outside company to come in? These are all considerations that buildings have to look at and take into consideration and talk to their experts, talk to their management company, talk to their lawyer, and think about to decide, are we even able to do this once we get to phase 3? And there's no clear answer on those things right now. But more importantly, I think buildings need to remember, and boards, as difficult as it may be, especially when you're getting a lot of pressure from your residents and your owners about using the pool, that the number one concern is making sure that everything's done legally and it's done safely. And that may mean sometimes making the unpopular decision. But that's what we're looking at when it comes to pools.
Looking at Sean Kent as the insurance specialist on our call, one thing that comes to mind, some phrasing we use when talking to boards about risk management and our managers about risk management, is that life and safety are paramount to every other concern that we have. This is a situation that has never been seen before in our associations. And I think the boards need to think about and be cognizant that life and safety are paramount to people's ability to enjoy sunbathing and swimming at the pool. That really
Sure.
needs to be where the board is focusing at that point. Which leads us to fitness centers and other amenities. Sean, did you have something to add?
Yeah, I mean, I was going to tack on to that, Jessica. I think you're absolutely right. I mean, I don't think that associations have never had to weigh a decision so heavily that could potentially impact the residents from a health standpoint the way that we're seeing it now, right? So we're talking about pools or amenities. The risk is you open your pool and you have a number of residents that contract the virus, and then you have a liability lawsuit on your hands. I think most of the professionals in our industry, legal and insurance, would agree that it's going to be difficult to prove causation in a case like that. But you couldn't have said any better. Paramount is the safety and well-being of your residents, right? So all of the decisions that you make must be relied on heavily by the advice of the professionals that you use, your counsel to begin with, right? So I think it remains to be seen how everything's going to unfold once we get to phase 3. But even then, is there any obligation to open amenities and pools? And is that the right decision, and how are you going to handle it, right? So whether or not there's insurance coverage in place, the fact of the matter is you have to be hyper-focused on the long-term well-being of your residents and do not get drawn into the impulses that you may have as a board member to make a decision because your best friend that lives next door is giving you a hard time for not opening the pool. And that's going to be difficult.
Exactly. To both of you, Laura and Sean, as it concerns or relates to fitness centers and pools, I've heard several boards ask, well, what about our waiver? We have people sign a waiver before they use it, so doesn't our waiver protect us? We can just open it up, and if they get sick, they signed a waiver.
Mm-hmm.
Well, I mean, from a legal standpoint, and I'll let Sean address it from an insurance perspective, but from a legal perspective, you have to keep in mind that, number one, waivers can allow people to release certain types of claims in certain circumstances against certain individuals who are parties to the waiver. But you've got to deal with minors who cannot execute waivers themselves, so you're going to have to be addressing those concerns. But you have to also remember that there is no ability to waive the right to comply with governmental regulations. And that's what we're really talking about here. If we get into phase 3 is, are we able to safely and effectively open the pool and comply with these requirements that are still there when we get to phase 3? Meaning, can we keep it to less than 10 people? Can we safely and effectively practice social distancing? And you can't waive the right, someone can't waive the right for you to have to comply with those governmental orders. So it's not always a foolproof solution. And as Sean will attest to from the insurance perspective, the mere fact that you have a waiver does not in any shape, way, or form prevent people from filing a lawsuit and us having to then legally contest the enforceability of that waiver and what that implies or affects. So it's not a foolproof solution to avoiding any potential liability. And more importantly, as we said, well, yes, we want to avoid the lawsuits and the litigation because of the expense. More importantly, we don't want to see our neighbors get sick or worse. So we need to make sure that we're keeping those things at the forefront of these decisions and these discussions before we make any choices.
Mm-hmm. Yeah, totally agree. I mean, that being said, Laura, I would still say any type of risk mitigation measure that an association or board can take that would further mitigate their potential liability or their potential risk in the event of, bodily injury through the contraction of virus, I'm going to advocate for that, right? And if it's something as simple as having a more specific waiver in place, it goes back to how do we enforce that, right? And I think that's an easier risk mitigation measure to enforce than many of the other things that we're talking about. So that's one of the other reasons why I like a waiver. It has to be more specific to the ones that we're used to for the use of amenities in pools. But, there's a reason why swim at your own risk signs are the industry standard, because it sets a different tone and a cadence, right? And it might cause somebody to think twice about the use of an amenity or a pool, specifically a pool, and the potential liability should they be injured, and maybe they recall that it's a swim at your own risk, whatever the case. I compare waivers similarly in the sense that I just think that it gets people thinking about the potential liability and the fact that they actually sign that waiver.
To that point, you just mentioned something, swim at your own risk signs. We've heard from several sources, and additionally, the CDC has a number of sample signs and posters and whatnot that you can post around that we're recommending our community associations post as well. But as communities are looking to reopen amenities, would you recommend a specific sign that calls out that COVID-19 may be present? Utilize this area at your own risk while following these certain measures?
Absolutely. I mean, as Sean said, I'm not in any way discouraging people from using waivers. My point is that when the boards say, well, can't I fix this concern I have by simply using the waiver, is that it's not going to be 100% guarantee, but it doesn't mean we shouldn't still try to post signs just like we would post signs in the lobbies or the elevator asking people to make sure they're following CDC guidelines and, recommendations from the Department of Public Health. We're still doing those things, right? We're posting those signs, we're sending out notices, reminding people of the things that they need to be doing and the dangers of not doing those things in that manner. So it absolutely can't hurt you to post those signs. And I would encourage it after consultation with legal counsel and everyone else to make sure that you're including the correct information. That's the one thing we want to be sure about, is we shouldn't just be posting signs willy-nilly throughout the building that we haven't considered the content. So let's again make sure we're having discussions about these things before we do them, because there are always consequences, down the road. And this is, like we said, this is the first time any of us have experienced this in our lifetime, and no one knows. And Sean mentioned this earlier. We don't know how the courts are going to come out on a lot of these issues. So right now, we really just have to think everything through and not make knee-jerk decisions without having all the information available.
Yes. I'd like to pivot a bit and talk about another hot topic that we've got going on is in-unit construction, especially our high-rise and mid-rise condominium buildings. There's been kind of a moratorium. Many associations have put a stop on some of that in-unit work, and now 2 months later, people are really itching to start working again. There are some people who are displaced in cases where they had started a remodeling project and they're living in secondary housing, waiting to finish their unit. Some people who are like, hey, I'm not working. Let me use this time to do something. Let me get something going. How do we guide our boards to address that in-unit construction and starting that up again? How do we reopen that process for the communities?
I think we need to look at it almost in the same way that we did when we started deciding what to shut down, right? On a case-by-case basis, to look at each project and to decide what can be done safely, how many construction individuals are we talking about for various projects, where do they have to come in and out of the building, is it going to require them to come into a lot of contact with other residents of the building, do they need to be using common areas, or can they specifically be limited to, back entrances and freight elevators, and can we do it safely? So all the factors that we considered when we decided what projects to shut down, those have to be looked at again, including whether or not the work is really essential at this point in time and it can be done safely. So we have to sort of try to go in the reverse of what we did when we started closing things down and start slowly peeling that back to make sure that we're taking into, safety and essential work into consideration first. And it really has to be done on a case-by-case basis. It cannot be a one day everything shut down and the next day suddenly we reopened any type of construction. I think that will definitely lead to bigger issues for us. So it's going to require some thought and some attention to detail of the specific projects and discussions and considerations of the various aspects of each of those projects.
And if I can add, the perspective of the building employees, the door staff, janitor staff, the receiving room staff receiving those contractors needs to be looked at. And also cleaning supplies, PPE supplies, if those are required to do it safely, do you have adequate supplies? So that should be in consideration as well. As Laura said, it isn't a light switch turn on and you get in-unit construction. There's some points that need to be thought about all the way through.
Ian, your point about the PPE raises another thing that I think is really important, is that we need to look at the contracts in place for some of the work, if they are association projects, or even for those that have been approved for unit owners for their in-unit projects. We have required in some buildings that have allowed certain projects to get started, we've required that there be modifications or addendums executed to those agreements to make sure that anyone coming in understands the rules and the PPE they're required to utilize on a daily basis, so that everyone is behaving in the safest manner possible. So we are protecting our staff and residents.
Yep.
Excellent. The last 2 points we had were really talking about board meetings and annual meetings, which are a topic in and of themselves. So I'd like to hand it over now to Ian Novak to talk about annual meeting procedures, board meetings, and social distancing.
Thanks, Jessica. So for the last couple of months, you as a board member, it's a different landscape of how you've been holding your meetings. completely upside down of what you're used to. You're holding meetings electronically, you're holding meetings telephonically, but business is getting done. We are able to move forward with the business of your community. So I just want to applaud all of you to getting over that large hump. So what I wanted to spend a few minutes on today with you is your annual meeting. I mean, whether your annual meeting is held in the next month or in the next 7 months, I think we can all agree that holding your annual meeting in a large room with members of the community is just simply not going to occur this year. I think we could also all agree that you as a board, along with your management team, should start talking now about how you are going to hold your annual meeting this year. In all sense and purposes, an annual meeting is just an opportunity for your community to cast a vote. That's it in a nutshell. We have used annual meetings at our communities to celebrate what we've accomplished together as a management team, as well as, more importantly, you as a board, and everything that goes with that. But when you really go down to what is an annual meeting, it's providing an opportunity for your voting members to cast a vote. And from that perspective, I'm going to go through tips of how to conduct a virtual meeting. We're going to go through rule change requirements and from the perspective of if your community is looking at possibly changing its format of holding a meeting to completely electronic with electronic tabulation, so online voting. And finally, for those of you who are not interested in online voting, some tips of the trade for non-electronic tabulation of how you can hold your annual meeting this year so that your voting members can simply cast their vote. So tips to conduct a virtual meeting. Have clear and concise dial-in and log-in instructions and repeat those instructions. So you want to develop the communication, you want to communicate that communication, and you want to repeat that communication. And you want to do that for each and every one of your meetings, because you will have new members of your community joining for the first time, either telephonically or online, to this meeting. And so you want to develop it, communicate it, and then repeat it. And on the telephonic portion, if you are able to, and you have administrator rights, either you as a board president or you as a property manager, mute all the owners and shareholders until it's time for them to speak at the open forum. If you're unable to mute on like a free conferencecall.com, you just simply build that expectation. You develop that communication, you communicate it, and you repeat it at the beginning of that meeting so that everybody understands, please mute your phones at the beginning of the meeting so that you can conduct your business. Have all your owners and shareholders submit their questions to the board before the meeting so that the board is, one, prepared to answer all the community's questions, but secondly, and most importantly, that you as a member of the community are going to have your question heard and answered, rather than if we can just pretend 20 or 50 members of the community all at the same phone call trying to get their question heard by the board of directors. Have clear procedures on how the open forum will be conducted and repeat those procedures at the beginning of the meeting. That way, I as an owner know what the expectation is of when I can be heard and when I can further comment on the meeting to that board of directors. And to just give a prime example, I'm going to read directly from a communication that from an association out to its members regarding this. Unit owners who wish to do so are more than welcome to attend the annual meeting by dialing into a conference line. The dial-in number is XYZ and the access code and password is ABC. In order to maintain good order, unit owners' phones will be muted, so only voices that will be heard on the phone line are those of the members of the board and management team who will be conducting the meeting. As it will not be possible to have a traditional unit owner question and answer period at this year's annual meeting, please submit any questions or comments to the management office before the meeting so that they can be addressed at the annual meeting. That's just a very simplistic but wonderful example of a board developing the communication, communicating it, and they're going to repeat it at the beginning of the meeting so that everybody understands the rules of the road for their meeting. Moving on to rule change requirements. Before I go into this, we're finding more and more communities, especially in the FirstService family, their boards are looking at an opportunity to changing their entire format of voting from either a proxy or a ballot, secret ballot, to changing to a completely online voting procedure with tabulation, so on and so forth. And from that perspective, and Laura, please tell me if I'm wrong, from that perspective only, the board does need to look at, with their attorney, at changing their rules as far as voting is concerned, because you're changing from direct balloting to an online platform completely. We're not talking about sending the ballots or proxies electronically. We're talking about the entire annual meeting with the voting procedures happening online. Is that correct, Laura?
That is correct. There are going to be a number of factors, so rely on your lawyers to help you with those.
And I'm going to be repeating that a lot with this topic. You need to consult with your attorney before you make any changes. Now, depending on if your community is ruled by SECA, the Illinois Condominium Property Act, or if you're a co-op, so non-for-profit act, there's some different rules that you need to know about. And the first thing we're going to talking about the ICPA, because that has the strongest impact to a board of directors if you're considering changing your voting rules. The rule needs to be adopted by the board 120 days before the date of the actual election. I'm going to repeat that, 120 days before the date of the actual election. And here we are in mid to late May, and if your election is in December, you have a very tight schedule to turn that around. You obviously need to develop the rule with your attorney. You need to distribute that draft rule out to your community for their review. And then you need to hold a board meeting with the opportunity of your owners to comment on that draft rule before the board, actually at a properly noticed board meeting, approves that rule. At that time, you need to start the clock 120 days from the date of your annual meeting. Now, there are rumors out there that the state is looking at that tough requirement and maybe easing back on it, but what we're hearing is don't count on it. Is there any, do you like to add anything to that, Laura?
No, I mean, there's a lot of things that are being raised with the state legislature right now, and until that happens, we really have to just comply with the rules we have in place. So if you're going to consider going into this direct balloting procedure, this electronic as you're talking, we need to really be cognizant of those timeframes and make sure we're not waiting until the last minute to begin that process.
Now, if you're a community under the SECA Act, the SECA is not as stringent. The SECA just allows you to change a rule as a regular rule. Make sure you distribute it to your community for their review. Have a board meeting that gives the opportunity for your community to comment on the draft rule before the board approves the rule. The only side comment that I should add is that the board should, the rule isn't into effect for that annual meeting, so the board approves it at that board meeting, and no communication about the annual meeting has gone out. Before that new rule was approved. And finally, for our co-ops out there, the biggest recommendation that we can give to all you boards are please review your bylaws, especially on it. You should be doing so on an annual basis, but your bylaws will tell you the rules of the road of your voting procedures and how to conduct your board meetings. Some are very, very finite with agendas written into your bylaws. Some are a little bit more relaxed. But from what I understand, Laura, boards of co-ops just simply need to amend the rule and approve it at a board meeting with a recommendation of at least sending out the draft rule for the shareholders to review before the board approves. Is that correct?
Generally, yes. So subject to obviously looking at their own governing documents, and also just, the Not-for-Profit Act is applicable to most co-ops. But yes, generally that's what a lot of them require.
Great. So electronic tabulation, let's talk about that for a minute. We did look at several third-party providers out there that provide a platform for an association, a co-op or HOA to conduct an annual meeting virtually, all online, voting all online. And what we learned is, well, it's a third-party platform. The community generally owns all the information after the election is completed, meaning all the ballots, all the information regarding that election is easily downloaded and kept by the association. Each owner has a unique ballot link to vote. So they are provided a very unique link only to their name, and only they can open it. We've learned that these third-party providers can process secret ballots as well as open ballots, and they can also conduct cumulative voting. So that's very important depending on your community. And finally, the cost we found is comparable to hiring a third-party tabulator. So depending on the size of your community, you need to ask that third-party provider, especially for our larger associations of over 500 units. But we're finding generally the cost is equivalent to the cost of hiring a third-party tabulator. The benefits, we found that communities are able to meet quorum due to easier procedures, especially those communities with a younger bandwidth of a community. Those members actually enjoy voting and going through those procedures with an online platform. And finally, it replaces the need for a proxy. The downsides are, one, you need a lot of time to set up to upload all your owner and shareholder information to the third-party platform. Now, obviously, we as your management company can assist with that endeavor, but do know that it is an endeavor. It is a task that needs to be done. And what we've already talked about is it does require a rule change requirement. And if you are a community run by the ICPA, it's 120 days. So that is the downside to that. And finally, just need to repeat, you do need to consult with your attorney before you make any changes to your rules, and also consult with your attorney if you are thinking about using a third-party platform for your annual meeting, so that they'll be able to guide you through the pluses and minuses and the do's and don'ts with that. I'm going to finish off by talking to the rest of our communities who are, how do I conduct my annual meeting this year? I'm not interested in an electronic third-party platform, changing the voting rules. I just want to get by in this COVID world. First and foremost, we do recommend that every community uses a third-party tabulator. Your property manager should not be tabulating the community's votes. And I need to repeat that. We do recommend that you use a third-party tabulator. And please speak with your regional director for options. Your regional directors of wealth resource for those options. And something we touched upon a little earlier is you do need clear and concise expectations on where and how the ballots and proxies will be sent to that third-party tabulator. And I'll get more of an example on that in just a minute. Finally, the ballot box. What do we do with that ballot box? So you need clear and concise expectations on when the ballot box will be removed from the common area, such as your lobby, so that ballots and proxies can be sent to the third-party tabulator for tabulation purposes. Long gone are the days where you could keep that ballot box until maybe 5-10 minutes before the annual meeting starts for those proxies and ballots to be tabulated. You do need your third-party tabulator. You do need to give them time in order to tabulate those votes. So with that in mind, I'm just going to read another example from a community that did hold their annual meeting just a couple of weeks ago of how they communicated to their community and built those expectations. As there will be no physical annual meeting at which unit owners can directly cast a vote, all votes will have to be cast by submitting a proxy form prior to the annual meeting. Completed proxy forms must be deposited in the voting box located in the lobby of the building or submitted to our auditor, ABC Company, by mail or by email to xyz@gmail before 4 p.m. on June 8th, 2020. Unless you direct otherwise, John Smith, the official tabulator, will act as your proxy and cast your votes exactly as you direct. So that is another really great example of very concise language used to build an expectation to your community of how the annual meeting will be conducted. I'm going to finish off by just a few questions have been raised by our communities, Laura. Candidates from the floor, is that a requirement each and every single year that the board must abide by for annual meetings?
There's nothing in the law that requires candidates to be submitted from the floor. It's simply just a tradition or let's say a habit that a lot of buildings have utilized over the years, but there is no legal requirement for that.
Okay, so with that in mind, you should not have a problem with candidates from the floor on a virtual meeting because it's not a requirement to have candidates from the floor. Please tell us the difference between a proxy and a ballot, Laura. There seems every year we come up with this topic and there seems to be confusion with our boards.
Yes, there is a lot of confusion around this. So a ballot is the actual ballot that your vote is cast on. It's the document that is maintained by the association as required under the Act for people to inspect or copy later. A proxy is a way that the law allows people who were unable to attend a meeting in person and actually physically cast their ballot in past times to authorize someone else to cast a vote on their behalf. And it can be done in a number of ways. It can authorize someone to do it specifically as indicated in the proxy. So it says, I, Laura Marinelli, authorize Ian Novak to act as my proxy and vote for the following candidate for my unit. Or it could simply say, I, Laura Marinelli, authorize Ian Novak to cast my votes in the manner he deems appropriate. But that proxy isn't the actual ballot. The proxy is what authorizes the ballot to essentially then be cast according to those instructions. So you still always have a ballot, even when you have a proxy. It's just that the proxy is what is given in advance. So it's not the same thing, but there's a lot of confusion about that.
Thank you, Laura. I bet I'll ask you that question again this time next year. The final question that we've been getting, the final question we've been getting from our communities that have held their annual meeting in the last couple of months in light of COVID. Owners voting at the last minute. I'm an owner and I enjoy going to an actual annual meeting with ballot in hand, and I like to officially cast my vote at the annual meeting. How am I able to do that? Are my rights being taken away? How can boards facilitate a meeting so that this owner or owners feel that their voice is being heard?
Well, there are a number of ways. You mentioned in your example materials that got sent out earlier for that meeting that's coming up in June, that you're still allowing the unit owner to cast their ballot. It's just that they're not going to be able to physically be in the same room as everyone else based on the current pandemic for safety reasons. So they can be provided with multiple avenues to do that. They can be allowed the opportunity to drop it in the ballot box up until a certain date and time. They can mail it to the management company, or if you've hired an auditing company, however that association has deemed appropriate, or they can be submitted electronically as long as certain requirements are followed. So individuals are still being given their right to have their voice be heard at those meetings. And again, you also mentioned in many cases where you're allowing owners to send in questions or comments or concerns. So again, they're still going to be having their voice be heard. It's just that your voice is going to be heard in a different manner than it was in past years, given the current safety concerns that we have.
Right. Another outside of the box idea would be that you could allow that ballots to be submitted in the ballot box up to the time that the annual meeting starts, and just not have the official results of the tabulation announced until the following business day to allow the tabulator time to tabulate. So as long as you've met quorum, then continue on with the annual meeting, but build the expectation to your community that they're just not going to have the final results that evening. It'd be another workaround.
That's a great idea.
So Sean, on an insurance perspective, do you have any stories from your front about annual meetings and insurance? And from there, could you guide us on insurance do's and don'ts in light of today's COVID world?
Yeah, I mean, one of the war stories that comes to mind is a claim that came from an association out of Florida. I mean, you hit the nail on the head in terms of the rule change requirement, right? So one of the most common causes of D&O liability claims is when a board makes a decision that deviates from the rules, right? I mean, that's the most common cause that leads to an allegation of negligence against the board. And we had one in particular in Florida where they decided to tabulate votes electronically, and there were a number of residents that decided they didn't like that decision and sued the board because it was not allowable in their rules, in their bylaws. So the defense costs for that particular claim, I think last time I checked, were in the $300,000 to $400,000 range. So another good reminder to make sure that before you do anything or make any decisions on how you're going to vote, that would be step number one. If you need to make a rule change, be sure to have that in place before doing so.
And consult with your attorney.
Okay, I think next section is insurance. Okay, well, again, my name is Sean Kent, and I'm responsible for the insurance division for FirstService Residential, which essentially means we have a team of licensed individuals who are wholly responsible to ensure that FirstService Residential managed associations receive the best coverage at the best possible market rates. If we boil it down to what our team is responsible for, that's it. But on top of that, of course, we are subject matter experts for condo, HOA, co-op insurance. So our property management teams, our board members, all of our associates rely on us heavily to be the subject matter experts and guide them through what can be a very complicated and specialized knowledge process in as far as it relates to insurance. So with that, I'll dive right in and really start with an overview of industry standard coverages. So my intent here is to really just kind of give an overview of what condos, co-ops, associations are responsible for purchasing in terms of insurance coverage, and then we'll dive a little bit deeper into, what's happening in the market on a global basis and how is that impacting our segment of business, especially in Illinois and condos, co-ops, HOAs, and then we'll touch a little bit on COVID-19, the implications there. But first things first, almost all associations have your property insurance, which would include business income, business interruption, which has been a hot topic these days, especially over the past 9 weeks. You have your commercial general liability policies. You have your directors and officers liability policy. You have an excess and umbrella liability policy, which sits on top of your directors and officers liability policy. At least it should. We hope it does. You have workers' compensation. Whether or not you have employees or don't have employees, we advocate for our clients to carry workers' compensation as a stopgap to some of the less likely types of claims that can happen related to contractors and vendors or board volunteers. And then, of course, we have flood and earthquake, and a less common coverage, but definitely topical, cyber liability. So we'll dive into a little bit of kind of what's happening in the global market, which has led to what we're calling a hardening market. Next slide, please. So really challenging times. If your association recently went through an insurance renewal, unfortunately, you may have felt the impact of what we refer to as a hard market in the insurance business. And really what's driving that are some of the events that have happened globally over the last 4 years. So between 2016, 2019, record insured losses for the insurance industry, especially property insurance industry. Hurricanes Irma, Maria, Harvey, really impactful over the last 3 to 4 years, and have really had an impact on what we're seeing globally. So on average, commercial insurance pricing increased 11% in fourth quarter 2019. That trend has continued through 2020. In fact, it's actually probably increased a little bit. Property insurance specifically has increased 13%. Again, that last statistic, late 2019, again, continued trend. Unfortunately, the multifamily sector, which includes condos, co-ops, apartments, any type of residential real estate, what we often refer to as habitational in our business, by far seeing the largest property rate increases. So 10 to 20% if you have good loss history, which essentially means you have no claims or few claims, and 30 to 60% with poor loss history, which means you have poor loss history claims. So, and what does that boil down to aside from rates? Much more restrictive underwriting. So the conversations and negotiations that underwriters are, that brokers are having with their underwriters have become much more challenging, where they are really, the underwriters are pushing back a lot more, looking to increase deductibles on top of rates, declining to quote new business altogether. So as board members, and for us as the insurance professionals trying to source quotes on behalf of our associations, it's been incredibly challenging to get not only a favorable renewal, but also multiple options to the table. In what is, kind of a common practice in the property management industry. Just there's an expectation that you have multiple quotes. It's become very difficult for us to deliver on that promise. So just one of the market challenges. So that's global, that's macro. And then the next slide, please. We'll dig in a little bit more to Illinois specific. Back one. Thank you. There we go. So Illinois condo co-op insurance market trends, much of the same. I would say Illinois, Chicago stacked condos specifically have kind of been shielded over the last couple of years from what we've been seeing in other major metropolitan cities. It hasn't been quite as bad, with the exception of the past couple months, unfortunately. So we really started to see the tide turn in Illinois over the last 3 or 4 months. And what that has translated into are increased property rates of 10 to 25% for average risk and 30 to 60% for loss affected buildings. Again, just buildings that have had more claims. On top of the rate increases, we have seen increasing water damage deductibles. And again, that's more for mid to high rise stacked condos, but also relative to townhomes as well. One of the main risk transfer mechanisms that underwriters are using to kind of improve on their loss portfolio and their loss ratios. And then we've also seen increased wind hail deductibles for suburban frame construction. Again, Illinois a little bit better than the norm in many other of wind hail affected areas. So Minnesota, for example, our Minnesota market has been feeling that pain over the last 12 to 16 months, and it's really just starting to impact Illinois this year. General liability rate increases, not too bad there, especially compared to a city like New York, where it's been much worse, but 5 to 10% for average risk, 15 to 30% for those that have had claims experience, especially if you have an open liability claim. It can be very difficult for a broker to underwrite, or to negotiate on your behalf with an underwriter if there's open liability claims. So that can be an impediment to getting a good renewal. And then lastly, umbrella pricing. Umbrella pricing increases and then also reduced limits. So what that essentially means is there's been a restriction of capacity within the underwriting markets. So many of you have heard of Lloyd's, London, all the above have decided that umbrella for this class of business has become much more challenging to underwrite. So what they have done is lowered the available limits that they're offering. So where we used to have $100,000 in available limits, we now only have 50,000, or I'm sorry, million. 100 million, 50 million is now the more of the norm now. So that's on the umbrella side. So 30 to 50% higher for average risk and 100% increases in some cases. And again, I mentioned limits being reduced on some of the condo specific umbrella programs. So as far as COVID-19 and the implications that it's had on some of the changes that we're seeing within the insurance marketplace, I wouldn't say that it's really been a primary factor. I would say more than anything else, it's exacerbated an already difficult market, right? So the hardening market was already happening pre-COVID, and then during COVID, it has become much more difficult in terms of the bottlenecks that are happening with underwriters and the submissions that they have and the uncertainty. I mean, we've mentioned the word uncertainty a number of times throughout this webinar, and underwriters don't like uncertainty, right? So some of them even have a moratorium on quoting new business for the next couple months until we understand what's going on. Others have capitalized on the opportunity, but by and large, it's really just exacerbated some of the challenges that we've been experiencing. So here's what we know, and much of this you will hear through CAI, who's already put out a number of publications and webinars on the topic, and much of this is in line with what's being communicated nationally through organizations like CAI, but very fluid situation. So almost all property business interruption, D&O liability policies contain broad exclusions for viruses, bacteria, et cetera. So that's a known. Property business interruption, specifically, we may be relating to two things. One, management fees or association fees. And if you have a commercial unit, a retail unit that has been impacted, they may not be paying their fees, right? So that's business interruption for condo and co-ops and HOAs. For that coverage to apply, the cause must result from damage to physical property. It's pretty unknown at this point whether or not bacteria, a virus, is actually going to constitute physical damage to property. I think that's one of those things that's going to evolve through case law. So that's what we know on the property business interruption. Most likely there's exclusions that just coverage is not going to apply. General liability, a little bit more fluid. So where early on in the process, we just assumed that most of the policies would include exclusions for viruses, pandemics, you name it, we're actually finding a fair amount of GL policies that don't have those exclusions. So many of those types of policies will defend in the event that there's an allegation of wrongdoing or negligence. But by and large, we're operating on the assumption that most policies are going to have those exclusions. So one thing that we can be sure of is there's going to be broader exclusions related to viruses and maybe even more specific language related to pandemics moving forward for all of these types of policies. And lastly on this topic, there's proposed legislation in some states where, states are trying to convince, enforce insurance carriers to actually pay for some of these claims that they're saying are automatically excluded. So we'll kind of see how that evolves. And then again, case law, there's a number of claims out there that are going to dictate kind of how this how the pandemic applies to the insurance industry and many of the types of claims that we're talking about. Next slide, please. Okay, so what should you be doing as board members? Again, a lot of common themes here. Exercise best practices with cleaning and communication to residents. Documentation, absolutely critical. Communication, absolutely critical. Rely on your FirstService Residential opening guide. I think as a company, that's something we're extremely proud of because it correlates to everything that we do to help our board members, our property managers make the right decisions, mitigate liability, and ultimately do what's best for the interest of your association. So continue to use all of the resources that are available to you. Report definitive claims such as a demand letter or proof of financial loss. So if you have a formal complaint of negligence, you have a demand letter, you absolutely have proof of financial loss. Regardless of exclusions that may be in place, we're advocating that you file that claim as soon as possible. We don't see any reason not to. And then keep in mind any claims that may happen throughout this time period as we're still kind of going through this lockdown. We're finding that there have been a number of incidents that just haven't been reported for one reason or another. I think we're kind of we're out of the woods a little bit in this topic because over the past 3 weeks, we've kind of have a little bit more sense of normalcy. But business as usual for anything unrelated to the pandemic. Please be sure to file any claims, whether it's water damage or claims of wrongdoing against the board, such as D&O liability. We want to avoid any potential declination of coverage because a late reporting, a late notice to the insurance carrier. And then lastly, again, common theme, practice sound business judgment, rely on your experts. Even a lot of the decisions that you may make as board members really are in good faith. For example, if you're thinking of buying masks for all employees and all residents and guests, just because it seems like a good risk mitigation measure, sometimes those types of decisions can go awry. So make sure you're relying on your counsel and your professionals to help you manage some of those difficult decisions. And we feel ultimately that the courts are going to side with the associations, the boards that were really well informed and did just that. So communication key, documentation, relying on your experts all help us through this.
Excellent. Thank you very much, Sean. Thank you all for your participation. We're going to throw it now back to Asa Sherwood, our president, for some closing remarks.
Thank you all for attending our webinar. We truly hope you enjoyed today's panel. As we continue to proceed through the phases of recovery, we look forward to recording future webinars and continuing to add value to our communities every day. Thank you, and be safe.